did the US Constitution break so easily? Is it broken? Or if so, can it be reassembled, made fit for purpose at this juncture, this moment of crisis in our country? To talk to us about this and answer questions you might have, we are privileged to welcome nationally recognized constitutional scholar Michael Dorf, the Robert S. Stevens Professor of Law at Cornell Law School, where he teaches constitutional law. Professor Dorf writes and lectures widely on presidential power, the Supreme Court, and the structure of American government. He was educated at Harvard Law School and served as a law clerk to Justice Anthony M. Kennedy of the US Supreme Court. He has authored or co-authored well over 100 scholarly articles and essays for law reviews, books, and peer-reviewed journals. For our purposes here, I will just mention his book on reading the Constitution, which he co-authored with Lawrence H. Tribe. He writes a bi-weekly column for Justia's Web. Am I pronouncing that right?
Yes.
Okay. Verdict, and posts on his own blog, Dorf on Law. I've been there. I suggest you do too. He also maintains an active pro bono practice and writes amicus briefs in Supreme Court cases. At the conclusion of his talk, Professor Dorf will be joined by Linda Meyer in conversation with him. Linda Meyer is Professor of Law Emerita at Quinnipiac University, where she taught for 30 plus years, has thought and written about the law and about constitutional issues, and would be able to talk to Professor Dorf and ask questions on the subject in ways that I certainly can't. And finally, the session will be open to questions from our attendees at that time. So please, if you like, do put your questions in Q&A or chat or whatever it's called, and do keep it short and succinct, please. Thank you so much for being here. Professor Michael Dorf, to you. Thank you.
Thank you so much for that generous introduction. And I want to begin with an apology that if you hear chewing or barking sounds, that's my dogs in the background. I had intended to use my AirPods, but we had some technical difficulties logging on. And so I want to just, I don't want to interfere with any of the sound. So that'll add a kind of homey touch if that comes up.
All good.
Yeah, so I also want to say how thrilled I am to be joining Linda for this. Linda and I began our careers as baby lawyers across the hall from one another as law clerks to two different judges in the U.S. Court of Appeals for the Ninth Circuit, and then we both moved on to she for Justice O'Connor and I for Justice Kennedy at the Supreme Court. So it's a nice reunion for me. Okay, so the topic is, why did the Constitution break so easily, and can it be reassembled? And so I thought I'd break my remarks down into three categories. Excuse me for a second. I'll take this stuff away from Blue. Don't you too loud, buddy. So the first question is it broken? Then the second question I'm going to ask is, if it is broken, who broke it? And, was it always that way? And then finally, I'll ask about what can be done, perhaps, to fix it. So I think, to my mind, there's very little doubt that there's something very wrong with our current system, the way it's been operating lately. And I'm going to give three core examples, two sort of chosen from the news of the last few days, and then one from just a case I happened to teach in my federal courts class today. Federal courts is a class for upper level law students that is sort of at the intersection between procedure and constitutional law. But I hope it's a case with which people are somewhat familiar. So I'll begin. My first example of a way in which the Constitution is broken is the fact that the United States is now engaged in a war overseas that the president started unilaterally without really any authorization from Congress. It's true, we've got a fragile temporary ceasefire, but if you go back to the start of this war at the end of February, right, President Trump launched it. He then at various times referred to it as something other than a war, called it an excursion, by which I think he meant incursion, but no mind, but has also referred to it as a war, and it plainly is a war. And yet, Article 1 of the Constitution gives the power to declare war to Congress, not to the president. Now, that has never been understood to mean that all uses of military force must be pre-authorized by Congress. So, for example, if pirates attack a U.S. ship, the U.S. Navy or Coast Guard can take action without waiting for authorization from Congress. Um, During the Civil War, we have a case actually from the Supreme Court. It's called the Prize Cases, which allowed that President Lincoln was permitted to use military force when the United States was attacked. But the general rule has been that for a major commitment of U.S. forces, that the president needs authorization from Congress. And that rule is embodied by the proposition that Congress, not the president, declares war. The president is commander in chief, but Congress makes the decision whether to go to war. And that's a deliberate choice on the part of the framers, who were worried that if the country is going to commit its resources in blood and treasure to a military operation, then it ought to do so only with the buy-in of the American people. And it's Congress that is closest to the people, not the president. Uh, Now, I don't want to suggest that this is unique under President Trump. Other presidents have gone to war without legal authorization, and you might say, therefore, unconstitutionally. And just to show a kind of interest in bipartisanship, I'll give two examples of Democratic presidents doing this. So you may recall that following the breakup of Yugoslavia and the civil war that ensued, there was a NATO action in Kosovo, and the U.S. Was providing the most of the forces for that. It wasn't not exclusively, but the U.S. military was involved. And President Clinton went to Congress, asked for authorization, and he was denied that authorization. He was denied that on an even vote in Congress, but they denied him the authorization. But he persisted in any event. And so that was an example of what you might think of as an unconstitutional war. It was arguably justified on humanitarian grounds. The Serbian forces were committing human rights violations of the Kosovars, but as a U.S. constitutional matter, there was a real problem with the war. Another example was President Obama's use of military force in Libya. There, the U.S. was basically serving as the Air Force for the rebels against Muammar Gaddafi. And a lot of people said, well, why doesn't the president seek authorization? After all, we have something called the War Powers Resolution that Congress passed in the wake of the Civil War. Sorry, not in the wake of the Vietnam War. And so the War Powers Resolution requires the president to give notice to Congress and to seek authorization, and it has various limits and has time limits. And what the lawyer for the State Department, who I'm somewhat ashamed to say is a fairly prominent academic, who's the former dean at the Yale Law School at the time, Harold Koh, he said, well, we don't need to abide by the War Powers Resolution here because it doesn't apply. It only applies by its terms when U.S. armed forces are engaged in hostilities. And there are no hostilities going on here because although U.S. forces are bombing the Libyan government forces, the Libyans are unable to shoot back effectively because our planes have taken out their whatever anti-aircraft they had. And so it's only one way. So it's not hostilities, which is a fairly that is as bad an argument as I think it sounds. So I think that the current action against Iran is arguably worse than Kosovo or Libya, partly on just strategic grounds, but also in terms of the scale. But it's not. There are many ways in which I think President Trump is unprecedented in this regard. Unfortunately, he has precedent in prior presidents. Okay, so that's one way in which we could think of that on a very, very fundamental matter. what branch of government gets to decide if the country is going to go to war, the Constitution is not functioning. Here's a second piece that comes out of that same constellation of issues. So the U.S. war in Iran is not only unconstitutional, it's also a violation of international law. International law allows for the use of military force in exactly two circumstances. One, when a country is attacked. The U.S. wasn't attacked. You could say, well, you can use military force if an ally is attacked. Israel, which is at war with Iran on the side of the U.S., also wasn't attacked by Iran directly. So that doesn't work. The other circumstance is if the UN Security Council authorizes the use of military force, which it didn't here. So the war from its inception was unlawful under international law. But starting an unlawful war isn't necessarily a war crime. However, the president, over the course of the last week, at various points, threatened to commit war crimes if the Iranian government did not accede to various demands. Threatening war crimes is not necessarily itself a war crime, but you might ask, well, what would have happened had he carried those out? That is, had he targeted civilian infrastructure? Would there have been any consequences for the president? Well, the answer to that is no. And why? Because, as I'm sure everybody here recalls, in 2024, the U.S. Supreme Court in Trump against the United States declared that the president is immune from criminal prosecution for all time, even as an ex-president, for all actions he undertakes within his core executive functions. And there's no question that serving as commander-in-chief of the military is a core executive function. Now, you might say, well, if that's what the Constitution says, I guess that's what it says. But of course, it's not what it says. The Constitution says nearly the opposite. So I'll read you from Article 1, Section 3, which is about impeachment. It says, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, you might say, well, the party convicted, and this was an argument that was made by then former President Trump's lawyers, you have to first be convicted. That's obviously a ridiculous argument. First of all, the point of that clause in that sentence is to say not when one can be tried, but simply that an impeachment trial is not a criminal trial. But it clearly allows for the separate possibility of a criminal trial. And it obviously doesn't depend on prior impeachment, because just imagine the president committed various crimes that weren't discovered until the president was out of office. That wouldn't preclude criminal prosecution. And yet, in Trump against the United States, the current Supreme Court said, nope, the president is immune. There are all these no kings rallies, but essentially we have our Supreme Court, and this was made clear by the dissent in the case, declaring that the president is effectively a king, at least in this respect. Okay, that's two examples of core features of the Constitution not being effectively not working. Let me give you a third example, which is a little bit more technical, but I'm going to try to make it as clear as possible. So I assume most people recall that in late 2021, while the Supreme Court was still considering but hadn't yet decided to overrule Roe v. Wade, the court decided a case out of Texas. Texas had passed this law known as SB 8 that banned abortions from very early in pregnancy, basically 6 weeks on, which was clearly unconstitutional. But the Texas legislature had some advice from a very clever lawyer who said, you know what? Instead of having this law be enforceable by criminal punishment, instead, we're going to deputize every person in Texas who opposes abortion to bring a private lawsuit to sue anybody who performs or assists in an abortion, and they can be liable for up to or more than $10,000 per lawsuit. Right? The whole point of this law was to make it extremely unlikely that anybody would risk performing an abortion, which they had a constitutional right to do at that time, because they'd have to worry that they could be sued by anybody in the state, anywhere in the state. Um, and because it was only private enforcement, there was no way to sue in advance to block it. Ordinarily, if a legislature passes an unconstitutional law, what a plaintiff can do is to go into federal court and seek an injunction or a declaration that the law is invalid, and then it doesn't get enforced. But by cutting out the Texas government officials, what Texas did through SB 8 was to make it impossible to sue somebody in that posture. Four justices of the Supreme Court, the three Democratic appointees plus Chief Justice Roberts, thought in that case, well, in light of that, we're not going to reward Texas for its ingenuity here in defeating constitutional rights. You should be able to sue the Attorney General or somebody to block it statewide. Another four justices, so a total of eight, allowed for a tiny category of lawsuits, but that was quickly wiped out when the Texas Supreme Court said, well, actually, those people you think have some authority to enforce the law, they don't have any authority after all. And so effectively, the upshot of the combination of this decision and what the Texas Supreme Court did was to say that for that period, basically December through June, December 2021 through June of 2022, before the Supreme Court had overturned the right to abortion, Texas had done so in a way that made it impossible for people to vindicate their constitutional rights. So I've now given you three examples, all of which are things that I just happened to be thinking about today because they're in the news or they were in what I was teaching, in which we see that the Constitution doesn't work in terms of the allocation of authority for declaring war, doesn't work for limits on executive power. After all, the country was founded by people who had fought a revolution because of what they perceived as royal abuse of power, and can be defeated even when it protects constitutional rights. So, to my mind, that makes pretty clear that the Constitution is, if not broken, well on its way to breaking. Okay. Now we have to ask then, well, so who broke it? I think it's tempting to say, well, sort of everybody, but if you look at my examples, you see with respect to the war powers, that's presidents abusing their power, right? Using their functional command over the military and disregarding what Congress has said. With respect to the immunity case, that's primarily the Supreme Court, although, of course, you wouldn't have had the case had there not been the behavior by the president and his allies in the wake of the 2020 election. And then with respect to Texas's SB 8, I guess we can put that also at the feet of the Supreme Court, plus maybe the Texas legislature. But I think that's a little bit too naive just to stop there. I think you have to lay a fair bit of the blame at the feet of Congress as well. Because if you think about it, Congress could have done something with respect to each of these. Congress could have withheld funding for the various wars. So the Kosovo example is quite odd in that Congress voted against authorizing the military action by NATO in Kosovo, but then voted to fund the war anyway. I understand politically why they did that. That is, it looks very bad politically to not support not give funding to the troops while they're in the field. But as a practical matter, it is a tool that Congress has that it didn't deploy. So, and then finally, with respect to the SB 8 litigation, Congress could have changed the law in some respects to provide for broader causes of action, and hasn't done that. Okay, so it looks like we could share the blame among all the branches of government, maybe some of the states as well. But maybe we want to go back further. Maybe the problem that we're seeing today was actually baked into the Constitution from the very beginning. And so I want to suggest now a possibility that the people who broke the Constitution were the ones who wrote it. But to do that, you have to think about, you have to put yourself in the mindset of the framers of the original Constitution. And I'm going to I'll give you a long quote from Alexander Hamilton and then a very short quote from James Madison. So the framers were confronting a number of issues when they wrote the Constitution. One of them, though, was how to have a democracy without descent into mob rule. And this was not for them a theoretical problem because the period from the late Revolutionary War through the Constitutional Convention, roughly a decade, saw state legislatures acting quite irresponsibly with respect to their debts and other matters, basically because of, in the view of the framers, an excess of populist zeal. And so that's one of the things they're trying to address in the Constitution. And so this is in Federalist One, the first of the Federalist Papers. This is Hamilton writing. So I'm gonna read you this. He says, "A dangerous ambition more often lurks behind the specious mask of zeal for the rights of the people, we might call that populism, than under the forbidden appearance of zeal for the firmness and efficiency of government. History will teach us that the former, again, populism, has been found a much more certain road to the introduction of despotism than the latter, and that those men who have overturned the liberties of republics, the greatest number have begun their career by paying an obsequious court to the people, commencing demagogues and ending tyrants." Okay, so those are, I think, prophetic words, and they also show a keen awareness of the risk of too much direct democracy, right? All right, so what's the solution that the framers come up with? Their solution is to disperse power through what we conventionally call separation of powers and federalism. And Madison sums this up in Federalist number 51. He says, "Ambition must be made to counteract ambition. The idea is that you pit the branches and levels of government against one another, and in the pursuit of their own ambition, they'll check one another. So that is the system of checks and balances." And you might say, well, they tried, but we messed it up. Except that it broke down almost immediately. And here's what I mean by that. The idea that you could have ambition counteracting ambition at the national level works if you imagine that members of the House of Representatives have a loyalty to the House, members of the Senate have a loyalty to the Senate, maybe to their home states, because before the 17th Amendment, they're chosen by state legislatures, and that they will be jealous of presidential power. But that doesn't work once you have political parties. Now, the framers hated the idea of political parties. They thought these were going to be factions, which would be the end of government. But almost immediately, you get political parties because there's really no other way to organize political activity without political parties. And so, when I say almost immediately, I mean really by the end of the second Washington administration, when it's clear that John Adams is going to succeed, is going to run as a Federalist, and Thomas Jefferson is going to run as on the other side. Adams wins the most votes. Jefferson comes in second. Under the original Constitution, Jefferson is Adams's vice president. It's a disaster because they're at loggerheads. In fact, the infamous Sedition Act, right, made it a crime to basically criticize various government officials, but it had an exception for the vice president, so you could criticize the vice president. Why? Because he was of the opposite party. So the whole thing was a disaster. And then in 1800, of course, you have for the first time what are effectively tickets. And Jefferson, of course, isn't going to run with Adams. He's going to oppose him. So Adams runs with Charles Cotesworth Pinckney. Jefferson famously runs with Aaron Burr as his running mate. But because you have this system in which the second vote getter is the vice president, people who are voting for Jefferson are also voting for Burr. And as we know, there dozens of ballots in the House to try to break the tie between Jefferson and Burr. Well, what happens? People at the time realize this is a problem and they fix it. What do they fix? They fix the election of the vice president through the 12th Amendment. That was an important thing to do, but it was tiny compared to the real structural problem. The real structural problem, the much bigger problem, was that now you have a system no longer in which Congress has an institutional interest in occasionally opposing the president because they have a commitment to Congress. what you have is party loyalty. And so instead of checks and balances, what you get is effectively oscillations between too much checking, what we could nowadays call gridlock, when Congress and the presidency are in the hands of different parties, and too little checking when, as now, Congress and the presidency are both in the hands of the same party. And so it was only a matter of time before those problems would manifest. Now, you might say, well, what do you mean it was only a matter of time? It seemed to work pretty well for 230 years. And I would remind people that no, it didn't. We had a civil war, which was not primarily about the breakdown of the system of separation of powers, but it was about other flaws in a constitutional system that tried to reconcile irreconcilables. The Reconstruction fixes a lot of things. It doesn't fix this basic problem. And opponents of the New Deal actually took the view, much like I'm taking now, that Congress, especially after the election of 1936, when Democrats sweep Congress, that Congress isn't a check on the presidency at all. And so that the system of checks and balances has gone away. Since the for a long period after FDR's death, you have the system working tolerably well, but only because the political parties for the roughly half century after World War II or so don't have strong ideological identification. So to make this sort of clear what I mean, for a very long time, and this persists really up until fairly recently, there are Southern Democrats who are more conservative than some Northern and Midwestern Republicans. And that means that party loyalty is not a sort of showstopper. One way, one thing that I think proves this is that when the House was about to issue articles of impeachment against President Nixon, right, it was Republicans in Congress who walked across the street to Pennsylvania Avenue and tell the president, "You've got to go," because they sort of put their loyalty was as much to the institution as to the president. Maybe that's because they were, more noble, more honorable people than we have now, but it's also, I think, because of the nature of how party politics has changed. So, from this perspective, it was only a matter of time before you would get an alignment in which you periodically have Congress either, again, at loggerheads with the president, and thus you have gridlock, or, as we have now, Congress basically rolling over and playing dead, so acting not as a check at all. And that is almost the opposite of the Madisonian system as it was originally envisioned. Okay, so that doesn't mean that I'm alleviating any of the blame I want to put on the current president or past presidents or Congress or anybody else or the Supreme Court, but it does mean that what we're seeing is in some ways a manifestation of the Constitution and not simply a breakdown of the Constitution. All right, so I've said that the Constitution is broken. I've given some idea about who broke it. The last question then is, what can one do about it? And here I think the only thing one can do about it really is to vote. So I want to go back to Federalist 51. I quoted Madison there saying that ambition has to be set to counteract ambition. In the very next paragraph of that same Federalist, Madison says this. He's talking about what it takes to sort of make the system work. And he says, a dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. So what Madison means by auxiliary precautions there is exactly the separation of powers and all of the checks and balances and these ambition counteracting ambition that he's talking about earlier in the essay. And he's suggesting, I think what I've come to realize is a fairy tale about how the American system of government works, right? The fairy tale is that, human nature is from time to time despicable, but we rig the system in such a way that it tamps down on our worst instincts. And what I want to say is that I don't know whether that's what Madison thought, but if it is, it was a mistake. Not a mistake to think you should have these auxiliary precautions, but to think that the auxiliary precautions are going to do the job if the people sort of lose their mind. And that has been the experience of the U.S. not only in the last 10 years, although certainly within the last 10 years, but also at other crucial periods. So if you look, for example, at free speech during wartime, there's a very good book about a dozen years ago by Jeff Stone, who's a constitutional law scholar at University of Chicago, called Perilous Times. And what he did was he went back to various periods in U.S. history when people had a sense of sort of existential risk. And what he finds is that in those periods, you get widespread censorship and very little resistance from any institutions. You can think about sort of other shameful periods in American history, the internment of Japanese Americans during World War II, right? That is, the institutions aren't sufficient. Another way to put this, I think, is the way that M. Gessen does in Autocracy Rules for Survival, which they published originally in 2016 in the New York Review of Books. And they have a bunch of rules. One of those rules is rule number 3, which is institutions will not save you. So in that sense, I guess at the end of the day, I sort of want to let the framers off the hook a little bit, right? That is to say, they designed a system that didn't work the way they expected it to work. In some sense, it didn't work at all. And nonetheless, with, sticky tape and, chewing gum and various retrofitting, we did make it work more or less for long stretches. But it's not surprising that in a period when, the reliance on the people, as Madison says, turns out to be misplaced, it's going to fail. So I'm going to stop there and welcome a conversation.
Thank you so much, Mike. That was just fascinating. And I hadn't really thought about it in terms of the political parties before, but I see your point. So my question is, insofar as any tweaking of the Constitution would help, if you could imagine for a minute that you could have the power to amend the Constitution, that you had a kind of widespread movement, would it be better to amend the Constitution to make it easier to amend? Would it be better to amend the Constitution to get rid of Trump versus US? Would it be better to amend the Constitution to, say, get rid of Citizens United? In other words, is there some kind of key amendment that we could think about that could help solve some of these breakdowns?
Yeah, I'm going to go with none of the above. I'll tell you what my two preferred constitutional amendments would be. So first, I would abolish the Senate, which is a highly unrepresentative institution, and overweights the votes of people living in small states, which are disproportionately, in general, but not universally, rural states. The second thing I would do is I would shift representation in the House to statewide elections. So, basically party list elections. And in this respect, I'm actually kind of an optimist. That is to say, I don't fully share Hamilton's worry about populism, in the sense that, while I agree, of course, there can be, very dangerous populist movements. For the most part, most of what I regard as the worst abuses by the Trump administration, certainly in the second term, are measures that are very unpopular and that would not have commanded the um, assent of the people as a whole. Now, it's true he did win the popular vote in 2024, by a historically sort of small to average margin. But you would have greater pushback from Congress if you had statewide elections. You would have less polarization in Congress. Um, and so I think those sorts of structural changes are in some sense more important. Um, I don't, that's not to say I'm against any of the things that you said. I mean, one of the problems with, clever lawyers can do a lot. So although I don't like Trump v. United States, in a sense, if you really have a president committed to committing crimes, um, he can probably get away with it by pardoning himself. Now, there's a literature on whether it's permissible for a president to pardon himself, but there's an easy workaround for that, which is you just schedule a colonoscopy, hand over power under the 25th Amendment to your vice president, and while you're under, the vice president gives you a pardon. And you would do this for the end of your term, so it covers everything you did while you were president. So.
Speaking of clever lawyers, all right. Thank you, Mike. I want to open it to other questions, though. Do other folks have things that they would like to chime in with, or concerns that you have about constitutional things that have been happening lately? We've had quite an education as a public about the stress testing of our Constitution, I think.
Yeah, I'm happy. I should say I'm happy to take questions about pretty much anything. I mean, at least ostensibly related to the Constitution or law.
Anyone?
I see someone.
Yeah, somebody unmuted, but I don't know whether you wanted to say something. Okay.
Did somebody want to say something? No.
We've got a question.
So I think
what is your opinion of ranked choice voting?
Yeah, so
Might it help with partisanship?
So it depends, right? So ranked choice voting in a district that's gerrymandered doesn't do you much good, because the problem there is I take it you'd have to have something like ranked choice voting without a primary, right? So because if you have primaries first, then you're going to have the problem we have now, which is that the primaries pull people to the extremes, and then that increases polarization. If you had ranked choice voting without primaries, I think that would, on average, probably lead to less polarization. So, but you can't do that by statute, because political party you need every state to sort of have these nonpartisan elections, and it would very much weaken the parties. I don't see, frankly, either party going for that. The only place where you get nonpartisan elections are in judicial elections, and even those turn out to be effectively partisan elections, because you don't see an R or a D next to the candidates' names, but you know what they are. But I'm not. I think ranked choice voting is a good idea. It prevents the spoiler phenomenon, but I think it's a relatively small fix. See another question in the chat.
I have a question.
Yes, Kendra, go ahead.
So I want to ask you about what a constitutional crisis would look like. So, for example, if Congress reconvenes and passes the War Powers Act and stops the war in Iran, and Trump ignores them and continues the war in Iran, what would that play out like? What would it look like legally? I mean, what would happen?
Yeah. So I'm gonna address the particular question, and maybe a few that are similar to it. I actually don't really like the term constitutional crisis, because I think it's a little bit ill-defined and people use it to mean different things. I mean, I think that by any layperson's definition, we are in a constitutional crisis. There's a website that I occasionally check in on that sort of lists all of the federal court cases in which the Trump administration has violated court orders, and the list grows every day. So to my mind, that sort of core of that. That is a constitutional crisis. It's very similar actually to the one you've hypothesized, right? You've got a clear edict from a branch of government that has the relevant authority, the courts or it's Congress, and then you've got another branch ignoring it. And the problem, of course, is that the executive branch has a monopoly on force. Um, so the I guess I think I would rather be in the world in which Congress voted to say stop the war and the president didn't than the world we live in now. Because in that world, that would mean that public opinion was sufficient to overcome party loyalty. And so maybe you could then, that in that same world, Congress could marshal the votes to impeach the president, right? I think a president who, but having said that, right, we have somewhat lower stakes examples of that thing happening right now. That is, the president is defying court orders. He hasn't yet defied a Supreme Court order, but there's nothing in the Constitution that says you get to defy lower court orders, but you have to abide by Supreme Court orders, right? And there's virtually no action being taken about that. So then there are all sorts of other things that are going on that are, clear abuses of power, and Congress is either, silent or supportive of what the president is doing.
I wanted to ask you about the notion that the president has control over the use of force. Is it not the case that the military swears an allegiance to the Constitution, not to the president?
Listening to a
Yeah.
vibrate
So
program.
someone's unmuted.
Kendra, could you mute yourself, please? Thank you.
Um,
Yes, go ahead.
Right. So excellent question. And of course, the answer is yes, that's right. Members of the military are legally obligated to disobey unlawful orders. But you may have noticed just a few days ago, a number of generals were essentially dismissed from their positions. Having talked to people with relevant experience, my best guess as to what's going on there is they were saying that they weren't going to carry out orders to attack civilian infrastructure in Iran, and so they were relieved of their duty. And so, in order for the um, the the uniformed military to frustrate a president bent on acting unlawfully, you need not just, a handful of people to stand up and do that. You need, a majority and clearly a majority of the leadership. And that's hard when, the Secretary of Defense seems at least as gung-ho as the president. And, eventually, presumably, they'll run out of generals to fire, but they haven't yet.
We have a question, Professor Dorf, from somebody else here in chat. What institutional groups that presently exist would be in a good position to challenge Trump in some of his recent unlawful actions?
Yeah, so there are lots of groups that are doing these challengings. So there's Democracy Docket, which brings a lot of cases involving voting rights. ACLU and other organizations have been helping out with a lot of the habeas cases for immigrants. There's no shortage of lawyers, notwithstanding the fact that early in this administration they tried to intimidate various lawyers by adopting those executive orders declaring various law firms that had either represented or included lawyers who had represented perceived enemies of the president, right? And some of the law firms capitulated. The ones that fought back have all won in their cases. The record with universities is not as good. With the exception of Harvard, every other university that has come under attack has capitulated. My understanding of Harvard is that they were kind of trying to reach a settlement. It's not like they were insisting on litigating the whole way. But then after the story was leaked to the New York Times that there was going to be a no dollar settlement, Trump decided, that was uh, not consistent with what he wanted. So they redoubled the attacks. So there are institutions, but I guess what I would say is um, there's a snowball effect one way or the other. So when the executive orders targeting the universities came out, I was among a lot of other people who was very much against negotiating or settling uh, on the theory that as soon as a handful of universities settle, they're going to get picked off one by one. So I think what you need is a kind of solidarity of resistance because no, I don't think there's any single institution that is sufficient to stand up. Well, one thing I've got a draft of a paper that I'm working on that sort of is a little bit pessimistic about this in the following respect, right? You might think that the bigger and wealthier an institution is, the greater its ability to stand up to the administration. But I think that that's naive. That actually it goes in some ways the other way, right? Which is that the bigger the institution, the more it has some kind of businesses that are subject to regulatory oversight by the government. And so the greater the opportunity, the more leverage points there are for the use of government power to extract other concessions. And you saw that, for example, with the Paramount CBS deal, right, where CBS aired this perfectly innocuous 60 Minutes episode, but nonetheless settled their case for $10 million or whatever it was. I might be conflating that with the ABC one, which was equally frivolous, right? So even though you want to stand up, you're just the institution is so big and is so dependent on the regulatory approvals that they can't do it, even if they want to. So for that reason, I think that makes solidarity among institutions all the more important.
All right, we have a comment here.
I can read it.
Yes,
so
go ahead.
so it says Kurt Gödel, the great mathematical logician, was right when studying for his citizenship. He concluded that the Constitution did not preclude a dictatorship. That is, that the U.S. Constitution was logically compatible with a dictatorship. He told this to his friend Albert Einstein, who suggested that Gödel not mention this at his citizenship hearing. It is known as Gödel's loophole. Right. So I actually think that Gödel was wrong about that. I think that the U.S. Constitution doesn't prevent a dictatorship, but the dictatorship would be unlawful under the Constitution. And now maybe that's not true. You say, well, what if they amended the various constitutional provisions that constrain the president? Yeah, I suppose that would get you there. But it's hard to amend the Constitution. So one of the questions Linda asked was, do I think that the Constitution should be made easier to amend? And like a lot of people, I'm of two minds about that. There are all sorts of ways in which I'd like to see it amended, but there are all sorts of ways in which I worry that if it's easier to amend, it would be made worse. I had a colleague who sometimes said, people say failure is not an option or things couldn't get any worse. He said that's not true. Failure is always an option and things can always get worse. So you want to be thinking more in a more optimistic frame of mind, like what can we achieve? But you also don't want to put what you have at too great a risk.
Well, California has certainly shown that an increase in direct democracy can certainly make things worse rather than better. The journalist who published that famous book just passed away today, and there was a great obituary in the New York Times today. And so, yes, I mean, you can by opening it up to that process, you can certainly drive it in all kinds of directions. I think no one knows what Gödel actually identified. and Gödel was quite a strange man. But um, the 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 more humanistic idea is that if you have a lot of bad people, like there's no kind of rule or no kind of constraint that will stop them.
Yeah, I think that's absolutely right. I mean, this is Gessen's point. Institutions aren't going to save us. It's a point that Learned Hand made in a famous speech. Learned Hand was this great judge on the U.S. Court of Appeals for the Second Circuit. He was a friend of Holmes, and he gave this speech about the Bill of Rights. And I'm going to paraphrase now, but he said that a Bill of Rights can only do so much. It's got to. What you need is the spirit of liberty to exist in the people's hearts and minds. When it dies there, no Constitution, no Bill of Rights can save it. And so yeah, that's right. No system is going to work if you have a society of sociopaths.
Or just ignorant people. I mean, they don't even have to be right. I mean, they don't even have to be sociopaths. That's a pretty high bar. I think they can just be, they can be ignorant and they could be, swayed by certain kinds of, anyway.
Yeah,
Can I raise a question?
of course.
Sure.
Yeah. So I'm curious about your take on the dilemma of the so-called unitary executive versus the regular. What we have is this vast regulatory complex, and the struggle between them. And you talk about how what's happening with the colleges and the others, where the regulatory structure is being used as a cudgel, a regulatory structure which was created in good faith, et cetera, et cetera. Could you just opine about that a little bit?
Yeah, sure. So I think that the unitary executive, to the extent that it gets carried out, so the unitary executive theory has a bunch of different tendrils. Right now, the one that is most in the news is the extent to which Congress may, consistent with the Constitution, place restrictions on the president's ability to remove members of so-called independent agencies, right? So there's the case currently before the court involving the Federal Trade Commission, that's Trump v. Slaughter. There's the Lisa Cook case in the Federal Reserve, right? And what Trump wants is he wants to be able to remove people at will and then to just put in acting heads, right? So, he got rid of Pam Bondi because she was unpopular or annoyed him in some way. But he's effectively turned the Justice Department into, his own personal plaything. The That's a risk under any circumstances because the Justice Department had a tradition of professionalism and detachment from the presidency, but it was never formalized. Unlike state attorneys general in most states, the attorney general is appointed by the president, confirmed by the Senate, but then serves at the pleasure of the president, right? So I'm not sure how you do it in Connecticut, but in New York, the attorney general can't be fired by the governor. And we've had times when they've been of different parties, even when they're the same party, they've been at odds with each other. And the idea there in most states is you don't want the most powerful people in the state controlling the prosecution apparatus. But that's not the way it works at the federal level, but it is true of a bunch of other agencies. And one of the things that the unitary executive does is to consolidate power in the White House as opposed to having it dispersed within the agencies. So an independent Federal Reserve, for example, is going to set interest rates in accordance with its best judgment about how to balance the risks of unemployment versus inflation. But one that's beholden to the president is going to do so based on its best judgment about what's going to help the president in the next election or even if the president himself isn't on the ballot. So I think the unitary executive exacerbates a problem, but I think we would have that problem anyway because a lot of the agencies that are sort of the sites of the most abuse are not independent agencies, right? So the FCC under Brendan Carr, right? That's not an independent agency. He's doing the president's bidding in ways that are, inconsistent with the First Amendment. If that were an independent agency, there would be, it would be much harder to get them to do that. I should say, though, that I'm on record as, being skeptical of the idea that Congress should make everything an independent agency. There are some risks from independent agencies as well. You want to have some political accountability. And again, in a sort of more normal administration, whether Republican or Democratic, there are norms that guide the extent to which politics will interfere with how they go about these things, right? So, under no, so I can't remember a time when the NIH or other all of the agencies within Secretary of Health and Human Services purview, right? Currently RFK Jr., right? There have been times when there have been people in that position who might have had some policy disagreements on this, that, or the other thing, but they, for the most part, let the scientists do their work. And so once that's not about the unitary executive, though. That's about this idea that, it's sort of I guess it's a kind of offshoot of the unitary executive. It's the idea that all policy is going to be done politically, as opposed to some of it just done on the basis of good government principles.
But when it comes to the question of the Constitution, to the extent that all of these various agencies have been established by Congress, but are supposed to, and I don't actually, when you say independent agency, and I don't dispute, all the problems we're having. I'm just trying to find a handle on the threads back to the Constitution.
Yeah, so let me give that. I think I can help out with that.
Okay.
So take Trump v. Slaughter. So Congress creates the Federal Trade Commission,
Right.
and it early in the 20th century, and it provides that members of the FTC can't be fired except for good cause. It's actually the statute says cause, but that means, as a term of art, means good cause. And in 1935, in a case called Humphrey's Executor against the United States, the Supreme Court upholds that. Says that these aren't pure executive officials. You want to have expertise, and so forth. That's now being challenged by the Trump administration. Trump administration is going to win. They're going to invalidate the removal restrictions on the FTC. The reason we know that is that they basically telegraphed that in an earlier case called Trump v. Wilcox. But the theory is that the theory that the president has, and this is the theory of the unitary executive, is that Article 2 of the Constitution says the executive power shall be vested in a president, right? So it says they mean the whole of the executive power. And John Roberts actually says that in the immunity case, Trump against the United States. It says that Article 2 vests the entirety of the executive power in one person, the president. And therefore, from that, they infer that if somebody's exercising executive power, that person must be subject to at-will removal by the president, because otherwise, how's the president going to ensure that it's his policy rather than this person's policy? Okay, that's the theory. That's how they tie it to the Constitution. But it's a very thin read. The Constitution only mentions one method by which somebody can be removed from office, and that's impeachment. So you might think that the default rule is if someone's appointed for a certain term of years, they can't be removed at all. Alexander Hamilton thought that if somebody is appointed with confirmation, and it requires Senate confirmation, then they can only be removed by the president if the Senate agrees to removal. That view has never been accepted, but it's a plausible view textually. I've got to say, my own view is that it's very strange to place so much weight on the vesting clause, because in that theory you couldn't have any executive officials at all. After all, I mean, think about. You might have somebody you can fire, but until you fire them, they can do all sorts of things that are in your name that are going to affect government policy. And yet we know that the Constitution contemplates there being not just a few other executive officials, but entire departments, because it refers in the opinions clause to, quote, heads of departments. So the Constitution contemplates the idea that there would be a federal bureaucracy, and I just don't see the textual case for saying because the president is the head of that, he gets to fire anybody he wants to within it.
Mhm. Okay, thank you.
Sure.
We're keeping you long. Professor Dorf, here's a question just before the last one was regarding, no, hang on. Is there any reasonable way to diminish the role of money in our political system? How does that relate to the Constitution?
Yeah, so that's right. Linda asked about Citizens United. So the sort of leading case goes back is a 1970s case following Watergate. Congress enacted legislation limiting campaign contributions and campaign spending. In a case called Buckley against Valeo, the Supreme Court sort of split the difference and essentially upheld contribution limits. That's why you can only give, it goes up each election cycle, but I think it's now 3,400, whatever it is, however much money you can give to a candidate in a particular election. But they struck down the expenditure limits because, and this is the controversial piece that people complain about, they saw spending money by a campaign as essentially tantamount to speech, and so it was a direct restriction on speech in violation of the First Amendment. So Citizens United extends that to so-called independent expenditures by corporations and unions. But Citizens United is the sort of whipping boy for this position. But it goes back really to Buckley, this idea that campaigns can spend unlimited amounts of money, and therefore they're going to find ways to raise or at least to marshal unlimited amounts of money. For a while, we thought that the solution to this was public financing of campaigns. Um, you know, so there was that. There still is the checkoff on your tax return if you want to give a dollar or $3 to the presidential campaign fund. The problem is that since President Obama turned down the matching funds, the candidates don't take that money anymore because they can raise more money by not taking it. The way it works is if you take the public finance, you agree to the spending cap, and so they don't want to be capped, so they don't do that. Um, there are locales that have public finance, and they work reasonably well. They're always vulnerable to being swamped by billionaire candidates who are spending their own money, and they tend to be unpopular because I think people don't, even though people don't like Citizens United, they don't connect that to public finance. This goes back to again to public ignorance, I guess, right? They don't what they think is, what, I'm going to be giving a bunch of money to a politician? I don't want to do that. I'd rather spend the money on our schools or something else that seems, more directly responsive to popular needs. Except the upshot is that you then have this opportunity for what is effectively, legal corruption, whereby candidates and then office holders do the bidding of whoever's funding them.
And people who don't have a lot of money or can't raise a lot of money can't run anyway. So that limits democracy in other ways as well. Linda, did you have any further?
I have one final question for you, Mike, and that is, given the fact that we are in this moment of constitutional stress and that people are learning a lot about the Constitution, and that it's difficult to find good information about anything these days, what is your second favorite source other than your blog for people to go to find good information about what's happening with the Constitution? And I'm definitely saying you should definitely read his blog. So
Okay.
Dorf on Law is a great blog. But is there another source that you would recommend?
Yeah, so I find SCOTUS blog to be very helpful. I mean, it is mostly focused on Supreme Court cases. Um, I I also think Lawfare has great stuff, and that'll keep you up to date more on some of the lower court cases. So I would choose those two. So there's stuff going on that's not exactly the law, and of course people have their sources for that, with it's the New York Times or whatever they're reading. But if you don't know lawfare, I highly recommend that as a possible source.
Is there something that might be more lay friendly?
Um, or lay friendly. Yeah, I don't know. I mean, there probably is. I don't. Those tend to be the places. I mean, the things I read that are not specialized stuff, the stuff everybody, I read the New Yorker, I read the New York Times, I get the New York Review of Books. I probably have something that doesn't have New York in the beginning of it as well. But yeah.
So Michael Dorf,
That's
I'm
great.
going to let you
Lawfare,
go.
sorry, Lawfare and Curtis Buck are great. Thank you, Mike. It was a pleasure talking with you. It was
Thank
great.
you.
I just say one more thing. I'm grateful to both Linda and you, Professor Dorf, for this. I just have one final question, and I don't think we have an answer to that really. Whether we're going to get past where we are right now to get to the point where we can begin to think about structural changes or constitutional changes or whatever kind of changes, because right now it seems very problematic. Would you agree with that? Or are you
Yeah.
more hopeful?
So I think I'm temperamentally optimistic, although I tend to be less so in my writing. But I guess I would say that history is long and it's often very surprising. I mean, things can change quite rapidly in wholly unexpected ways. Just to give an example, right? So I'm 62 years old, so not especially old, but not especially young either, right? I remember when, flying on airplanes when there was a smoking section, right? Which is an insane idea, right? The idea that you're in this enclosed space and you can smoke in this area, but not 2 seats forward, right? And all of that changed, and it changed very rapidly. Um, there are other things, there can be rapid political change as well. And, one thing that, crises do is they make possible more radical change than is, on the table in more placid times. So I wouldn't, I think it's very hard to predict where we'll be in, 6, 7 years.
On that note, thank you very much indeed. Everyone who was able to join, my apologies again for the glitch in the beginning. I think we lost quite a few people who tried to join up and couldn't do so. But I'm glad for those who hung around. And again, Professor Dorf, I'm very, very grateful. Linda, thank you so much. And perhaps we'll talk again in sunnier times.
Thank you very much.
Good night to all of you. Thank you. Bye-bye.